I bring my greeting to Dr. Zaharo, the lecturer of the Jurisprudence course. My name is Heng Exi with metric number 254807. So in this video, I will present about my assignment 3, which is the video on the topic of contributions of Dworkin's right thesis. So now, let's start with the introduction. For the background, Sir Ronald Dworkin, as a positivism more significant critic, he rejects the positivist theory on every conceivable level. Also, he denies that there could be any general theory of the existence and also the content of law. He even denies the local theories of particular legal systems that can identify the law without recourse to its moral merits. Meanwhile, he rejected the whole institutional focus of the positivism. Law theory is about how case ought to be decided, and it begins, but not with an account of the political organizations within a legal system. Sir Dworkin is famous for his critiques over hard legal positivism. The moral principles that people hold dear are often wrong. Even it is to the extent that certain crimes are acceptable if one principles are skewed enough. And all the interpretations must follow from the notion of law as integrity, as according to Sir Ronald Dworkin, to make sense and interpreting the law according to a community. Dworkin moved away from positivism's separation of law and morality, since the constructive interpretation implicates the moral judgment in every single decision about what the law is. So now, I will proceed to the contributions of Sir Dworkin. I categorize the contributions into 4 sectors, and the first one is law as seamless web. Law is to be treated as seamless web, where there are always a right answer. And different judge may come to a different conclusion or different judgment, but Sir Dworkin insists that judge may not only rely on their own political views, but on their belief in the soundness of those convictions or acquittance. He even rejects the view regarding judicial discretion. For example, the judge often are heard to say, we found the law to be this, and they say they discovered the law. But according to Sir Dworkin, they do not profess the law to be their own discretion. Apart from that, judges are always constrained by the law. They are controlling the standards which a judge is obligated to be followed. Dworkin objects to judge acting as a deputy legislator. Why? Because there are 2 reasons. First one is regarding the separations of power. It offends the democratic idea that communities should be governed by elected officials answerable to the electorate. The judge not being elected must not substitute his own will or own intention as against the legislature. And the second one is retrospective and the rule of the law. Let's say if a judge, he makes a new law and apply it to retrospectively in a case before him, then the losing party will be punished not because he has violated the rules, but rather a new duty created after certain events. Secondly, it was the judicial discretion as a contribution of Sir Ronald Dworkin. The judicial discretion focuses on the position where a rule has not been posited. For example, in the case of skateboard, the actual legal position is likely to be focused on the language. Is that skateboard a vehicle for the purpose of a bylaw which prohibits the vehicle to be used in a Hyde Park? However, it does not extend. There is a gap in the law. Both sides cannot refer to a decided case law. Dworkin, in his intention, he wishes to consider carefully what lawyers are actually doing as a matter of legal principle in hard cases. Also, he was not satisfied with the extension of rules by the analogy. Firstly, the discretion is not freestanding but only a part of the process. Secondly, it does not exist except as an area left openly by a surrounding belt of restriction. And thirdly, not outside the law but internal to the law. Let's say, if the judge simply exercise discretion and make new rules, they would be changing the rules of the game. As an alternative theory, Sir Dworkin made a distinction between strong and weak discretion. Strong discretion is where the officials are bound by the pre-existing standards set by the authority. Meanwhile, for the weak discretion is when the standards cannot be applied in a mechanical way. The strong discretion does not exist for judges, but the weak discretion is a part of the judicial role. The discretion is controlled and there are no gaps in the law. For the third contribution, it's an analysis of the legal rules against principles. To express and protect the rights in the legal orders is a main objective in this. And also to insist that the law is not merely rules, induces distortion in legal reasoning. So in the operation of the legal system, the policies are not appropriate to legal reasoning, and principles are more important than the rules, as they are surrounded by the structure of the rules. Dworkin also argues that in hard cases, judges make use of the standards that do not function as rules, but even operates as principles, as there's a conflict of two rules. One will be wrong and be invalid. And to support it, in the case of Riggs against Palmer in the year of 1889, a man named Elmer, he murdered his grandfather in order to inherit all his estate, his will, and his property. Had the court taken the positivist view that all the laws are valid by the former test, as what Hart thesis, the court would most probably decided in favor of Elmer. However, the court did not allow Elmer to profit from his own wrong. That decision proceeded not on the rules, but rather on a principle of law. Nullus commandum capris protects de injuria sua propria is a legal maxim that means no one can profit from his own wrong. Rules have a different meaning and may have a different effects when you apply it in a relevant principles. In every single adjudications of hard cases, there are always a controlling standards which the judges is obligated to be followed and to be bound by. With this, the judges are constrained by the law. And also, the last contribution by Sir Ronald Dworkin is the rule of rights against rules. It distinguishes the rights from the rules. Rights is stated as more fundamental than rules within the legal system. But rules actually express the rights, but the rights exist before their expression in the form of rules. This is as opposed to Hart's view, where rights is developed from legal rules. Rights is said as more important is because rights is being developed in the legal system through the working out of the political morality. All in all, Dworkin's right thesis asserts that a right legal answer would be the one that asserts and protects the rights which are explicitly or implicitly in the fundamental values within the legal system. Judges must always have the ultimate wisdom from the history of decision and also the understanding towards the political value of a system in order to achieve the right answer instead of the wrong one. And Dworkin also constructs a model of such a judges called Hercules. Even though Hercules is only an ideal model, judges have an obligation to aim for the right answer. And that's all from me. Thank you.